Good day and welcome to Letters and Politics. I'm Mitch Jeserich. The United States Supreme Court is set to hear oral arguments over Colorado's decision to disqualify Donald Trump from the ballot. At question in the case is Section 3 of the 14th Amendment to the Constitution that disqualifies former office holders who participated in rebellion or insurrection from holding political or military office in the future. Originally, it was used to bar former Confederates after the Civil War. It's only been invoked a handful of times ever since. Today we turn to the history of this section, Section 3 of the 14th Amendment, why it was written, what the debate over it was like, how it was used, and what a Supreme Court decision on it now could mean for the future. My guest for this has written an entire book about this very topic. Our guest is Mark A. Graber. Mark A. Graber is Regents Professor at the University of Maryland Carey School of Law. He's the author of a number of books, including the one on this topic, which is his latest book called Punish, Treason, Reward, Loyalty. It's part of a series of books that is called The Forgotten 14th Amendment. Mark Graber, it is my good pleasure to welcome you to this radio program.
Thank you for having me.
It's good to have you. It's funny, we've done a number of shows on the 14th Amendment throughout the years. I think it's one of the most important amendments to the Constitution, an amendment that has really forged our political debates and movements and struggles, I think, here in the modern world. Things like birthright citizenship and equal protection under the law. This is equal protection under the law was something that was very much related to the Brown versus Board of Education decision. But every time, until now, I've talked about the 14th Amendment with someone about the history of it. Section 3 would just come up in quick passing and sort of talked about in a way it's not even really that important to look into it. And now all of a sudden, the Supreme Court seems to have a date with history when it does take up this very section.
Well, it's interesting. When I started the project of the Forgotten 14th Amendment, its theme was simple. For us, Section 1 and to some degree Section 5 of the 14th Amendment are the most important, to the point where, for all practical purposes, the Constitution we teach goes Section 1, Citizenship Clause, Equal Protection Clause, Due Process Clause, Privileges and Immunities Clause, ... Section 5, to the point where most law professors could not have told you what was in Sections 2, 3, and 4. And it turns out, for the people who ratified the Constitution, who framed the 14th Amendment, Sections 2, 3, and 4 were the most important sections. They thought Section 1 was largely redundant and unnecessary. The only thing that has changed is suddenly Section 3 to us has become important. And so now the history, which I thought I was doing simply as an historian, isn't this interesting? This is their life world, how it differs from our life world. This history has now become important to our life world.
And it makes sense that Section 3 would be a major part of this amendment when it's being formed, when it's being debated, when it's being ratified, because this is just immediately after the Civil War, and this was a question of really barring former Confederate officers from holding office. So that makes sense. This would be a huge debate, a huge issue at the time.
Well, a very fundamental purpose of the 14th Amendment was not to get rid of slavery. The 13th Amendment does that, but to destroy something Republicans before the Civil War called the slave power, a belief that slaveholders had disproportionate influence in the United States. And what Section 3 does says if you were a past state or federal office holder, and slaveholders, powerful slaveholders, inevitably held an office in the state government, in the federal government, and in the military, you were disqualified from holding any office, state or federal, in the future unless amnestied by 2/3 of Congress. So unless you were generally contrite, you would be out of power. And the theory was that, in fact, these slaveholders had disproportionate power. So if there was just a new generation of Southern leadership, nobody thought they'd be radical abolitionists, but they'd be like small farmers in Indiana, racist, but not nearly to the same degree as Southern racism that led to slavery.
What was the fear? Was the fear that if federal officials, A, would be elected to office after the Civil War, and B, that then they would come in and restore this quote unquote slave power, sort of undo the things that were gained after the Civil War?
Well, there are a set of fears. Fear number one concerns the federal government. And here we should talk about Section 2 as well as Section 3. One of the great sort of we didn't think of it moments in American history is only after Congress sent the 13th Amendment to the states did somebody realize, the 13th Amendment says all African Americans are free. It used to be that African Americans enslaved counted as 3/5 of a person. Now they'll count as full people, but they're not going to be allowed to vote. The result is the former Confederate states will get a 30-vote bonus in the House of Representatives and in the Electoral College for persons of color who do not vote. And given that they get, about a third of the votes in the North, that third of the votes in the North, combined with the 30-vote bonus, will enable the South to control the national government. So we need to do two things. First, we need to get rid of the slavocracy bonus. That's Section 2. Second, we need to neuter the slaveholding leadership. That's Section 3. And we need to neuter the slaveholding leadership, not simply in the national government, but in the states. No secessionists can be allowed to have power in the states.
That's really interesting to me, and this is an important point about the Constitution before the Civil War. The 2/3 clause that people who were enslaved counted as 2/3 of a person. Of course, slaves were unable to vote, but it would count towards a state's population, towards representation in Congress, hence giving the South even more power. So after they abolish slavery and then make African Americans a full person, they did not give them the right to vote, but now that they're a full person, they actually gave the South even more representation than before the Civil War. Unequal.
That's correct. By the way, the clause is the 3/5 clause,
3/5,
not
forgive me. Yeah,
the 2/3
I always
clause.
screw that up.
Yeah, no, we're never good with fractions, but that's absolutely right that you actually see as a precursor to one person, one vote. This is considered the Equality of Representation Amendment. Section 2 is, in fact, the main amendment. You see newspaper articles in the states saying what's really important is this equality of representative. One vote in the North should be worth the same as one vote in the South, or it shouldn't be the case that the consequences of secession is you get more votes than you had before. And they're deathly afraid of another secession or the slaveholding power, the slave power they called it, coming back, dominating the United States. One of the things I was writing about in the project is an older idea we associate with the framers. It's been lost today, and it's called parchment barriers. We have the idea too often that if we write something down and put it in the Constitution, it will be enforced, even if there's no political will to enforce it. So if we write an amendment that says, for example, where all persons shall be allowed the bathroom of their choice, this will be enforced even if nobody is interested in enforcing it. The framers in the 18th century knew that was wrong. Over and over again, they said, we don't need a Bill of Rights. Why? Because if you elect the wrong people, they're not going to enforce it. If you elect the right people, it's unnecessary. What my research had discovered is 19th century Republicans felt the same way about the 13th Amendment. They said it's really nice to say no slavery. But if it turns out the people, government, are anti-slavery, they will enforce the 13th Amendment. If the people are pro-slavery, they will find ways around the 13th Amendment. So it's not enough to say nice things in the Constitution. You need a political system that will get people committed to enforcing the Constitution.
And that's a driving force of Section 3 of the 14th Amendment.
Sections 2 and Section 3 are designed to ensure people are committed to enforcing the 13th Amendment.
What was the debate at the time like in Congress over this particular section? And I don't know if you could divorce it from the other sections of the 14th Amendment. You probably can't, ultimately. And what was it like nationally? And what was this aimed with particular people in mind, or was this just a general sense of former Confederates?
Well, the first debate in Congress takes place within the Republican Party. The original 14th Amendment has a clause that says, essentially, anybody who participated in any way in the rebellion and insurrection cannot vote until July 4th, 1870. It's disenfranchisement. And there's a statute that disqualifies certain Confederates. This barely passes the House. It runs aground in the Senate. It runs aground in the Senate for a number of reasons. The first is they figure it's just impossible to enforce. Second, there are just too many people being disenfranchised. Third, it's too short a time period. It's in some sense too lenient and not lenient enough. Moreover, there's another problem. Can Congress, by statute, add qualifications to office holding? That wasn't clear. So the solution was, at a Senate meeting, they jumped the disenfranchisement provision and substituted a disqualification provision. And they did something very interesting, and they clearly debated it. One disqualified provision listed various Confederates, the president, the soldiers, members of the cabinet, legislatures, and said these people are disqualified. But Senators Daniel Clark of New Hampshire and Jacob Howard of Michigan wanted a broader one. They said, we're not simply interested in disqualifying Confederates. We are interested in disqualifying anyone who participates in an insurrection. And so they deleted the language for specific people being disqualified and said, if you are an office holder who participates in an insurrection or rebellion, you are disqualified from future office. So that was the debate among the Republicans. Now, Democrats said, you can't do this. First of all, you're disqualifying all the better people of the South, to which Republicans said, yeah, that's the point of the thing. The second thing they said is this is a punishment. Republicans said no, it's a qualification. You cannot be president of the United States if you're 31 years old. My 6-month-old grandson has just learned to sit up. He's a genius, well qualified to be president, certainly as qualified as some people running for office, but he's not 35. He can't run. So similarly, if you've participated in insurrection, it's not a criminal punishment. It's a qualification. And that was the Republican response.
So the fact that the amendment itself does not include the word Confederate or former Confederate, it just says if you held office and you participated in insurrection or rebellion, that is what would disqualify you. So it's purposefully created to go beyond just the Confederate people who were in the Confederacy.
That appears to be correct. Here's what we know. And by the way, here is what we don't know. It's important in these things to understand some things we don't know. In late April, early May, the Republicans in the Senate suspended Senate business and held a parley just among Republicans. And by the way, there were a couple of Republicans who didn't like the 14th Amendment. They were excluded. We know from newspaper reports that they were considering a version of the 14th Amendment that listed various Confederates. We know they were also considering a version that spoke of past and future. We don't know who said what in the parley. We do know what came out was the more general Section 3. We do know that Republicans said one of the points of this is it disqualifies past, present, and future insurrectionists. So that's what we know about Section 3. So we don't know all the details of the parley. I wish we did. I've been hunting various reminiscence, various other things, but a lot of it is simply lost to history, and we're stuck with that.
In 1872, Congress would then pass an amnesty for Confederate members other than the highest ranking officials within the Confederacy so that they could hold office again. But between this period, I remember many years ago, I think his name was Philip Dray, who wrote the book Capital Men about the first African-American lawmakers in Congress. And after the Civil War, we get a number of African-American members to Congress. Joseph Rainey, Hiram Revels. Is this part of the reason? And then after a few years, we wouldn't have any for many decades to come. But was the fact because of Section 3 disqualified so many people from holding office those first few years after the Civil War? Was that part of how we end up getting a good group of African-American lawmakers just after the Civil War?
Well, what happened actually is a slightly different story. We got a very good group of African-American lawmakers for two reasons. First, the Northern Union Army made sure African Americans were allowed to vote. Second, in many of the states, local state laws forbade former Confederates from voting. So you had an electorate that was heavily skewed to African Americans. Part of the reason for the Amnesty Act was Republicans said, okay, if African Americans vote, they're electing really good people. We don't need to enforce Section 3. This turned out to be a major miscalculation. Once white Confederates started to vote, they voted for Confederates who simply were eligible under Section 3. And through various, both legal tricks and frankly, out-and-out violence and brutal violence at that, African Americans were disenfranchised.
This is Letters and Politics, and we are in conversation with Mark A. Graber, Regents Professor at the University of Maryland, Carey School of Law. We're in conversation about his book, Punish, Treason, Reward, Loyalty. It's part of a series of books, the first of a series of books that's called The Forgotten 14th Amendment. We are talking about Section 3 of the 14th Amendment that disqualifies former office holders from holding office again if they participated in insurrection or rebellion. Can you talk to me about what we're talking about today with the case that the Supreme Court is going to hear concerning Donald Trump? We hear the term insurrection. What does, legally speaking, insurrection mean?
Confident. I know what insurrection, legally speaking, meant in 1866. I'm not an originalist. Whether it has the same meaning today, I can't tell you. But there was a long tradition in American law beginning in the late 1790s, going through the whiskey insurrection, the Freeze insurrection, the Burrs insurrection, the Dorr insurrection, the Taos insurrection, lots of insurrections. And they said an insurrection is not necessarily an attempt to overthrow the government and cause a civil war. Rather, an insurrection has four elements, and anything that has those four elements is an insurrection. First, you need an assemblage. Some people say an assemblage is you and I, two or more. Some say you need a little more than that. You need an assemblage of people. The people have to be resisting law. If it's an insurrection against the state, they're resisting state law. If it's an insurrection against the federal government, has to be a federal law, but they're very clear. Can be any law. Justice Benjamin Curtis says, I'm not going to, say these laws are more important, these laws less important. If they are resisting a law, it can be, in modern terms, the parking laws in Washington, D.C. You're resisting them, you meet the second element of insurrection. So we have first an assemblage, resisting a federal law. The resistance must be, third, by force, violence, or intimidation. If you're resisting by protest alone, that's constitutional behavior. If you're resisting by voting the bums out of office, petitioning the state legislature, giving money to a candidate, those are legal. Rather, once you use force, violence, or intimidation, now you've met the third element. There doesn't have to be actual violence. If you show up with guns at the tax collector's house and the tax collector flees before collecting taxes, that's the element of an insurrection. Last, it has to be for a general public purpose. So imagine the mob, January 6, 2021, was there to get congressional furniture to sell on eBay. That's a private purpose. There's a very famous case, or was famous in the 19th century, where a man had his boat seized by customs officials, and he killed a custom official to get his boat back. And he killed with a lot of men. Well, there was an assemblage. He was resisting federal law by force and violence, but his purpose wasn't that he thought the customs law morally wrong. He wanted to get his boat back. So an insurrection simply means, again, you have first an assemblage. Second, they are resisting a law. Third, the resistance is by force, violence, or intimidation. And fourth, the resistance is for a public purpose. You think the law wrong. You challenge the authority of the federal government to pass such a law. So again, a burglar doesn't challenge the laws of property, simply out for themselves. Whereas, to take an example used, people who rescued fugitive slaves were challenging the authority of the government to render fugitive slaves back south.
What's important to know about insurrection before the adoption of the 14th Amendment? I mean, we think of the Civil War, obviously, and that rebellion, and I don't know if there's a difference between insurrection and rebellion, but you did go through a list of insurrections that had occurred in history. Was this after the Constitution was adopted?
Yes and no. In one sense, the American law of insurrection was after the Constitution was adopted because there was no constitutional law beforehand. But the American law is based on the English statute of treasons and English understandings of that statute. The statute of treasons was passed in 1351, and it had 7 different forms of treason. Among them, by the way, was forgery. Americans said that's way too much. Americans said, for our Constitution, there are only going to be 2 forms of treason: participation in an insurrection or rebellion, and second, giving aid and comfort to the enemies of the United States. Now, having said that, Americans then adopted, by and large, the English understanding of treason. And I'll give one example that's very germane to the events of January 6. Blackstone has a rule, the Latin of which I can't pronounce, but it's basically, in treason, all are principles. What does that mean? Well, this goes back to our first year course in criminal law, which I will try desperately to distill in about a minute and a half and maybe fail miserably, so ask me follow-ups. Imagine you sell a gun to a person knowing that person plans to use the gun to murder someone. Under the criminal law, you are not a murderer. You have aided and abetted a murder. So that's a lesser sentence. It's still a severe sentence. The difference is if anyone does anything, knowing that it facilitates treason, you are not an aider and abetter. You are a traitor. So in the Civil War, someone gave the following example. You're a shoe salesman. A Confederate soldier comes up to you and said, my shoes are worn out. I need to wear better shoes into battle. You provide the Confederate with shoes. Your motive may have been you wanted to make money, but you knowingly assisted a member of the Confederate Army. You're a traitor. Notice another feature of this. It doesn't matter that you played a very small role. You provided any assistance to an insurgency or rebellion, you're a traitor. This was, importantly, the law before 1861. It was generally agreed upon. I looked through every text I could find. I find no one before the Civil War challenging this understanding of participation in an insurrection.
How do you distinguish between, and as you know, many argue that what happened on January 6th at the Capitol was a riot that got out of hand, not an insurrection. And how do you distinguish? And again, according to Section 3 of the 14th Amendment, it says insurrection and rebellion. I don't know if there's an important difference between those two words, but I certainly have been at protests that have erupted into a riot. I would characterize it that nobody was trying to bar them, those folks who are participating in those, from holding office. How do you distinguish when you look at something like January 6th between a riot and insurrection or even rebellion?
Insurrection, rebellion. The 19th century doesn't make as clear a distinction between rebellion and insurrection, but what it does is sufficient for our purposes. So there are some people who say a rebellion is an attempt to overthrow the government, and insurrection is merely an effort to either challenge the enforcement of a law or resist a government proceeding. Other people say, no, actually, insurrections are both overthrow and lesser thing. A rebellion is over an overthrow. So in the one version, insurrection and rebellion are separate. Under another, rebellion is a more serious insurrection. Doesn't matter for constitutional purposes because everything is either an insurrection or rebellion. Riot. A riot is spontaneous resistance to a law. It is not interference with a government proceeding. It just happened. And so a very crucial question, January 6th, was, did people intend that Congress be intimidated by force or violence? Did Donald Trump have that intention, or did someone just lose their temper? In other words, and there's Trump speech back. Did some people say Donald Trump gave a peaceful speech, there was no intention behind it? Others say it's an insurrection because the intent was to resist. It's a bit like the difference between murder and manslaughter. And I should note that my first year criminal law course, which emphasized that difference, was over 40 years ago. So if some caller says he doesn't know what he's talking about, they may be right. But the basic idea is murder is the intentional or knowing, planned killing of someone. Manslaughter is you just got really mad at the person in front of you, lost your temper, hit him with a metal pole, and broke his skull and killed him. So the issue is, how spontaneous were the events? Did Donald Trump just lose his cool? Or was Donald Trump self-consciously attempting to affect the course of the peaceful transition of power by intimidation, force, or violence? That's the issue.
Is that a hard thing to prove? Because obviously we can't get inside Donald Trump's mind.
In one sense, it's hard to prove. It's hard to prove in the sense of, intention is always difficult to prove because we can't get inside of anyone's mind. But there's a lot of public evidence. So as one treatise said, in looking at intent, one of the things we can look at is past action. Was it the case that Donald Trump accepted the result of the 2020 election and just lost it? Or was it the case that Donald Trump was systemically working to illegally undermine the results of the 2020 election, in which case we would interpret his speech as part of that behavior? What did Donald Trump do when the riot broke out? So these are evidence of intention. The same sort of evidence we use to determine intention when A has killed B. Intention is not easy. We can't read people's mind, but the law relies on intention, and the law points to lots of things as evidence. Same evidence that we point to if you think Donald Trump did it. And by the way, if you think Donald Trump didn't do it, you also point to extrinsic evidence saying, here's why I think violence was the furthest thing from his mind on January 6th.
Mark A. Graber is our guest. He's a Regents professor at the University of Maryland Carey School of Law. We're in conversation about his book, Punish, Treason, Reward, Loyalty. We're focusing on the third section of the 14th Amendment that disqualifies individuals who have participated in rebellion or insurrection from holding office. Is it disqualifying people who only held office before, not someone who engages in insurrection and rebellion but didn't hold office?
You're right. It only applies to past office holders. As one Republican said, these people have compounded treason with perjury. This is a culture that takes oaths seriously. When you put your hand on the Bible or whatever text you hold sacred, and you say, I promise to do something, this is considered not simply a ritual, but a firm commitment. So people who took an oath of allegiance to the United States had a special duty not to participate in insurrections or rebellions. If you did, you were disqualified. It was considered people who did not take that oath, maybe they should be punished. But you couldn't say they weren't trusted with official power. It's only people who had official power and violated their oath that could not be trusted to use official power in a bad way in the future. My apologies for the word salad.
No, but they violated their oath.
Yeah. That was very important to them.
Yeah. With the adoption of the 14th Amendment at the time, was there an understanding of how the law would be executed? Who would decide who was qualified, who was not? I believe in 1869, Supreme Court Justice Solomon Chase wasn't a Supreme Court decision, just sort of his own opinion, wrote something to the extent of it lacks how to be executed, how to carry this law out. So did the people who wrote this, who framed it, was it debated how it would actually be follow through with this law to enforce it?
There was no specific debate on how to enforce Section 3, nor for that matter was there a specific debate on how to enforce the 13th Amendment or other provisions of the 14th Amendment. Congress generally assumed that once the 13th Amendment was ratified, slaves were free. Congress, and here people generally said, once the 14th Amendment is ratified, these people are disqualified. As was common in the United States this period, people thought states would take the first step. Some states did take steps to prevent slavery. Some states did take steps to disqualify. If Congress,
so a state moving on its own on this disqualification issue is not unheard of, because that was one of the questions I had.
It was a common practice.
Yeah, because that was one of the questions I had with Colorado. I was like, well, who's Colorado to decide?
Well, Louisiana moved on their own. North Carolina moved on their own. Georgia moved on their own. Florida moved on their own. Huh. Lots of states moved on their own and began to disqualify people. Congress was dissatisfied and passed some procedures, but it's very important to note, when Congress passed the procedures, they didn't say states and the Union Army, which was also enforcing Section 3, were acting illegally. They said they were acting inefficiently. We've got a better scheme for doing this. So the 13th and 14th Amendment permit Congress to adopt unified national rules. They don't require Congress to do so. Otherwise, you have to have the position that if Congress repealed the laws, slavery could exist in the United States today because no state could ban slavery in the absence of a congressional ban.
But the third section of the 14th Amendment doesn't even say whether or not you could be on the ballot. I mean, this would be used with Victor Berger, I think, in 1920, and Congress voted him, I think, out of office after he won in Wisconsin, and then he was on the ballot again the next in the special election, and he won again. So Section 3 doesn't say that you're barred from the ballot; it says you're barred from holding office.
Well, now here's a choice. Remember, we have to implement Section 3. And the question of implementation is whether this is a reasonable means of implementation. If a person is disqualified from office, it might be reasonable for a state or for Congress or for the Union Army, as the Union Army did, to say, let's take this person off the ballot because people are wasting their votes. So if we have someone who is 34 years old and not eligible to be president, people may not know that. If this person is on the ballot, they may vote for this person, not knowing they're wasting their votes. So if we weren't talking about Donald Trump and someone said, there's a candidate who's not eligible for the office, but a lot of people don't know that. Should we put that candidate's name on the ballot? I think common sense would say no. When we talk about Donald Trump, sometimes common sense goes out the window.
Victor Berger, was it the Supreme Court that overturned his exclusion?
No, his exclusion was never overturned.
So he didn't serve in Congress.
Yeah.
After 1920.
Was excluded.
It seems like with this case now facing the Supreme Court, a decision that we anticipate to come shortly after the hearing in early February, it seems like the decision could range. And I heard you in another interview say that if the originalists on the court were to take a true originalist approach with this case, they would actually uphold what Colorado has done. But I can see that's hard to imagine this court actually doing. However, I can see a decision in which it's very narrow, just about this election, just about Colorado or Maine, narrowing it, having a very narrow decision. But on the other hand, you could also have a decision in which it lays out who determines who is ineligible, lays out sort of a whole process of how you even determine, again, who has been involved in an insurrection or rebellion against the country.
Possibilities for the Supreme Court are not endless, but they're close to endless. And in fact, we could probably be here for another 5 hours if I had to outline them all. But we can go from extremely minor decisions. So the court could say, you can't disqualify in a primary election. A primary election is largely private. The parties can put up whoever they want. It's only in the general election. In which case, all the Supreme Court has done is delay things for 5 or 6 months and probably delay things in a very, very bad way. They could make a decision of the form, something about this case is wrong. We don't like the procedure Colorado used. Use a different procedure. They could say, it turns out Trump didn't make the right objections at trial, so he's disqualified, but if somebody makes different objections, maybe they're not. So it's important first for everyone to know that while everyone is expecting an earthquake, we could get a tremor that we can barely measure on anyone's instruments. One possibility they could say is, in fact, that in the absence of congressional legislation, states can do whatever is reasonable. Colorado has done what is reasonable. So Colorado can take Trump off the ballot. In the absence of congressional legislation, Florida can keep Trump on the ballot. Each state decides for itself until Congress steps in. Another thing they could decide is, nope, Trump is not disqualified under Section 3. That's an earthquake. They could also decide he is disqualified under Section 3. That's an earthquake.
They could. The Supreme Court could say, we're not just upholding Colorado's decision, we're disqualifying you ourselves.
Yeah. They could say that. There are all sorts of permutations in what they could say.
Section 3 of the 14th Amendment has been used more recently. In fact, a case out of New Mexico that was related to January 6th. You testified in this case as a witness, as a historian about the amendment itself. What's important to know about what happened in New Mexico?
Okay, well, first, that in fact, someone was disqualified. I should always emphasize that when I testify as an historian, I do not testify about what happened in current events. I can tell if the lawyer says, here's a hypothetical. I can say, here's what people in 1866 would think about it. But history doesn't tell us what Donald Trump's intentions were on January 6th, or whether Mr. Coey Griffith, who was the defendant in New Mexico, performed certain acts. The significance is that, in fact, a judge in New Mexico recognized Section 3 was not limited to Confederates. January 6th was an insurrection. It wasn't the Civil War, but not all insurrections have to look like the Civil War. And people who encourage violence on January 6th were insurrectionists, disqualified from holding public office.
Tell me just quickly, we have about a minute left, and forgive me for giving you a big question here, but I did reference that that you make an argument that if the originalists on the Supreme Court were to stay true to their philosophy, their legal philosophy, that they would bar Donald Trump, that they may bar, I should say, Donald Trump from holding office.
To elaborate, the notions of free speech in 1866 are quite narrow. Trump's stronger case relies on notions of free speech that only develop in the late 20th century. In 1866, they said, you sell a shoe to a Confederate soldier, you're an insurrectionist. We might decide we want more consequential behavior. In 1866, they said, you violently resist any federal law or disrupt any federal proceeding, you're an insurrectionist. We might want to narrow the notion of insurrection. But if we go by what they thought in 1866, it's very clear that on the common understanding of the facts, which may be wrong, Donald Trump was an insurrectionist. If Clarence Thomas decides that for Donald Trump's sake, he is a living constitutionalist, the arguments are more difficult. I'm inclined to think the arguments are still compelling for disqualifying Donald Trump, but they are significantly more difficult.
Mark A. Graber has been our guest. Mark A. Graber is Regents Professor at the University of Maryland, Carey School of Law. He has joined us for a conversation about his book, Punish, Treason, Reward, Loyalty. Mark Graber, I've enjoyed our conversation very much, and I thank you.
Thank you.